you are helping aging parents or aging loved ones manage daily money matters, then you should probably be named their power of attorney. Now, what exactly is a power of attorney? Don't worry, you don't have to go to law school or have a law degree to be your parent's power of attorney. It's simply a document, a legal document like this one that lets your parents name someone or more than one person to make financial and legal transactions for them. Without this document, you don't have any real power to make financial decisions for your parents. You can't sign checks for them. You can't talk to their financial institutions. You can't sell their house if necessary. You have no power, no legal power to manage their finances unless they have named you power of attorney. Ideally, your parents should name you their general durable power of attorney. General means you have broad powers as opposed to limited just specific types of transactions. And durable means that the power of attorney takes effect immediately and it remains in effect even if your parents are no longer mentally competent. And you want this. You don't want to lose that power if your parents are diagnosed with dementia and now can no longer manage their finances on their own. You want that power of attorney to remain in effect. So they should be naming you their general, durable power of attorney. Your parents should meet with an elder law or an estate planning attorney to draft this document. Now, I know that there are free and low-cost DIY power of attorney documents available online, but these are often more general documents and they might not be tailored to your parents' specific situation. They might not even comply with the state laws of where your parent live. That's the benefit of meeting with an attorney. You can find an estate planning or elder law attorney by doing a search on your State Bar Association's membership directory. Find someone in their area, help them set up an appointment. It's so important that they meet with an attorney and sign this document while they are still mentally competent. If you wait too long, especially if they're suffering any sort of memory loss and they're no longer competent enough to sign this document, then you'll have to go through the court system to be appointed your parent's conservator. And this can be an extremely lengthy and expensive process. Essentially, you have to put your parents on trial to prove that they're no longer competent enough to manage their finances on their own. So it's so important to get your parents to meet with an attorney as soon as possible to draft this document. Now, once the document is drafted, you don't have any real power until you have the actual document. You're going to need this document to show it to your parents' financial institutions to essentially prove to them that you have the right to be making financial decisions for your parents. Don't give financial institutions the actual document though. You're going to want to give them a copy. Sometimes they're going to ask that that copy be notarized, certified that it is legitimate. Some financial institutions might also require you to fill out some other forms. Now, if you are working with your parents together on their finances and they've gotten this document, ideally, you should be going with your parents to their financial institutions to give them the document, to introduce yourself. This is going to make the financial institution feel a lot safer about allowing you to use this power. Financial institutions are very careful about protecting their aging clients against elder fraud, and there are plenty of people out there who will abuse this power of attorney. So if you can go with your parents to their financial institutions, that's ideal. But it's not required. You might run into a few obstacles sometimes though, and if you do, I would encourage you to reach out to your parents' attorney and have them get on the phone with the financial institution just to let them know that yes, indeed, you are the power of attorney. Your parents were competent when they signed the document. Putting all this in place though ahead of time before there's any sort of emergency, before you ever have to use power of attorney is ideal. Now, if your parents are reluctant to give you this much power, two things you should point out to them. First, by naming a power of attorney, by putting it in writing, they're getting to choose someone they trust to make financial decisions for them. If they don't sign this document while they're competent and someone has to step in and help them, that someone might not be the person they would have chosen. and that person could end up going to court and getting the rights to manage their finances for them. So you want to let your parents know that by drafting this document, the choice is theirs. They get to choose who is going to be making these important decisions about their finances going forward. And you can also let your parents know that if they're reluctant to hand over this sort of power right now, tell them to put the document someplace safe and tell you how to access it and under what sort of circumstances you can access it. You could even ask them to make a list. And then if, for example, mom is diagnosed with dementia, dad has a stroke, you can go back with that list and say, hey, we agreed that under this circumstance, I could now access that power of attorney and use that power to help you with your finances. And so letting them know that they don't have to actually give you this power right away by hanging on to the document, it's going to help them feel perhaps a little bit more secure about making this move. But it is important, once you are acting as power of attorney, that you have an actual copy of the power of attorney, the original document, and you keep it someplace safe. You don't want to let it fall into the wrong hands. But again, this document is so important to have. It's really the keystone of being a financial caregiver.